All right. Before we talk about the types of transactions that are covered by each system, let's talk a little bit about sales law in general. What's the history of sales law? And the law of sales has evolved over the years. Modern sales law depends on the contract. The sales contract is how we conduct trade in goods. And the sales contract, what makes it so special is that it is a universally recognized mechanism for how goods are to be sold. Every country in the world recognizes sales contracts as the means of conducting international business transactions. So the sales contract has an elevated status in the law, and we'll be talking a lot about that. The agreement of the buyer and the seller is going to be found in that sales contract. And therefore, all of these things we're talking about in terms of performance, the answers should be within the contract. The contract sets out the rights and the obligations of the parties. I have a right to receive money. I have an obligation to ship the good that I have sold. Now, in the sales contract, we mentioned the buyer and the seller are going to manage risks. And whenever we talk about sales law, we're talking that body of law that governs sales contracts. And sales contracts could be for not only for present real goods, but future sales of goods. Goods that aren't even created yet could still be subject to a sales contract. Now, as we mentioned, these sales contracts, it doesn't apply to contracts for real estate or intangibles, things like stocks and bonds or intellectual property, employment, insurance, services. The sales contract does not reach those issues. Today, the sales law of most nations can be found in modern commercial statutes or codes, oftentimes supplemented by case decisions, by case law. Case law gives us a way to interpret a statute, and so case law remains relevant even if there's a statute as to a particular issue.